Thank you for your perspectives on the importance of secure cross-border communication and the challenges of e-codex and the user-centric approach. We are taking another step now within this vital area for the eJustice project for the European Union. The digitalization of cross-border judicial cooperation is now the subject of our next speaker, Gösta Petri, Deputy Head of Unit eJustice, IT and Document Management from DJ Just. Please take the stage. Good morning.
Well, good morning to everyone, and many thanks to the Portuguese presidency for inviting me and allowing me to present the work that we are currently doing on digitalization of judicial cooperation. So I think I have a little presentation, if we could have it presented. So I do not myself see the presentation. Okay, I will try to give you my presentation anyway. So, as I said, the idea here was for us to, at the level of the Commission, to consider the next step in taking forward the digitalization of cross-border judicial procedures in the EU. We have, as has been presented already by the earlier speakers, by Christian, by Alain Pilette, the eJustice has progressed in steps, and the eCodex initiative, of course, is the tool that has been put forward to facilitate cross-border cooperation in the justice area, and specially designed then for cross-border communication in judicial cooperation and secure communication for the various procedures adopted in the area of judicial cooperation. Now, this has been, eCodex is a tool that is available for voluntary cooperation. The question arises, and is highlighted in the Commission's communication of last year, that we might want to move forward and see about whether we could really take a step forward and enable full digitalization of those procedures, and maybe even towards default use of the digital channel and making the communication mandatory. We have some context to be referred to here, which is a bit also, apart from the communication, the basis for this work. Last year we had conclusions of the Council on the 9th of June 2020, Shaping Europe's Digital Future, which set out an ambitious agenda for more globally for digitalization. And then this was followed up on the 13th of October 2020 about Council conclusions on access to justice, seizing the opportunities of digitalization. And I'd like maybe to quote here some of the statements in these Council conclusions, which really point forward to the work we're doing. And that is that the Council asks, particularly the Commission, to build on the progress already made towards the modernization of cross-border exchanges between authorities through digitalization, and looking also at particular issues such as service of documents and taking of evidence, and asks the Commission to continue to examine the potential for modernization of the core provisions of instruments in the field of civil and commercial matters in line with the digital default principle. And Council, with regard to criminal matters, considers that the Commission should consider to add other judicial cooperation instruments to the applicability of the e-evidence digital exchange system that Christian Nicolau was speaking about, and that has been set up, which already supports the European investigation order, but could very easily be extended to other instruments. Now, so what do we want to do from the Commission side? Well, we want to see about the fact that at the present, these judicial cooperation procedures have not been digitalized. And this, we think, is a problem. Why? Well, actually, we do note that many exchanges across borders still take place on paper. This is slower, it's less efficient, and of course has a number of costs, which we could save if we used instead electronic means. And obviously, as we have seen and witnessed during the COVID-19 pandemic, the paper channel, as we may call it, is very vulnerable to crises, such as the COVID-19 pandemic. This state of things with still a lot of use of paper means that the justice sector actually lags behind other sectors. And this is something we need to do something about. And in terms of the legislation, then we see that there are limitations in what we have for the time being. We have, which has been powerful, but we have voluntary participation in the digitalization. The pilots run under eCodex. Principle is voluntary participation, and each country is free to decide whether to participate in a digital exchange project. Which of course means that not all countries do participate. When it comes to exchange of documents, there is uncertainty about whether they are the legal effects of such documents. And we have also issues with regard to the use of electronic signatures, whether they are recognized and whether the assurance levels are appropriately set. Furthermore, the problems that we see are driven by uncertainty about data protection regulation, interoperability. There's different types of solutions developed in different countries, which may cause interoperability issues. There are varying degrees of digitalization between the member states. And of course, a lot of national legislation, national procedural laws may prevent member states from using digital communication. With this in mind, the objective of the initiative that we're working on, the overall general objectives is to increase the efficiency and resilience of the communication taking place. Also, more specifically, of course, our overall objective is to improve the access to justice for citizens and businesses. So it's efficiency and access to justice. This translates into a number of specific objectives relating to cross-border communication. To have this electronic channel that I spoke about, to ensure the acceptance of electronic communication and the legal effects of documents, deal with eID and electronic signatures, maybe look into video conferencing and data protection, of course. Now looking more particularly at the electronic channel, it is crucial to keep the electronic channel technology neutral, we think. So if we think about legislation in this context, it should not be prescribe a specific IT solution. We have a precedent also, important to mention, the recent revisions of the Service of Documents and Taking of Evidence regulations, for which, where these issues that I mentioned were actually regulated. So the mandatory use of a digital or electronic channel was laid down in those revised acts, and we should follow and look upon the precedent set by those regulations. And it should be a decentralized system. When we talk about judicial cooperation, it should allow communication from the competent authority, judicial authority, court, to the court or authority in other member states. The legislation could lay down this fact that it should be decentralized and the basic architecture for it. And of course, should be designed so that e-codex could be used, even if this is not explicitly mentioned in the legislation as such. We are looking into then the acceptance and legal effects for documents, as I mentioned, to make sure that the digital documents will be accepted and granted legal effects. And we are looking into, for our impact assessment, doing a comparative analysis on this point to really see what the member states' national laws says about acceptance and legal effects. We have to look into, as I mentioned, eID and electronic signatures and seals. The e-codex negotiations show that these are important issues that we need to tackle. In the e-codex framework, there was something called the Circle of Trust Agreement, which was required in the absence of legislation. So now we need to set these things. We need to ensure mutual recognitions of the e-seals and e-signatures using eIDAS regulation as a basis. And we should also look into setting the assurance levels for the different procedures. Should the signature be a qualified signature or an advanced electronic signature, and so on and so forth. With regard to video conferencing, the pandemic has showed the need and usefulness of video hearings. So participation from abroad, however, by video conference may not be actually legally possible in all member states. There is some legislation on this. There's the taking of evidence regulation in the civil area for civil proceedings, but then solely restricted for this situation of taking of evidence. So the question is, should we extend the rules that we have by allowing participation by video conference, perhaps for all cross-border civil proceedings? So that's something that we might be considering. And of course, data protection. We are talking here about decentralized system, and there we have to set the roles and responsibilities of the different controllers, which would be the member state authorities, the sending authorities and the receiving authorities. Some kind of provisions would need to be set in a legal act on this, in line with recommendations from from the European Data Protection Supervisor and European Data Protection Board. With this in mind, then, we have the policy options that we're considering for this new initiative. It's either an instrument that would digitally enable cross-border judicial cooperation, but not making the use of any IT system mandatory. Or we're considering another more far-reaching option to digitally enable cross-border judicial cooperation with the mandatory use of a secure electronic channel. Of course, if we say that there should be the use of a secure digital channel should be mandatory, there may be very good exceptions for that, which would be foreseen in such an instrument. But in both cases, we are probably thinking that there should be an obligation at least to put in place a digital channel for communication, so that you can receive communication from another member states in all cases. We are also in this context considering having an electronic access points for launching requests and receiving responses, claims, etc. on the European eJustice portal. We are also, of course, considering how this should look like in terms of a legislative instrument. And there are basically two ways to do this, as either having a horizontal legal instrument that would regulate this, or so an horizontal instrument which would contain the provisions on the digital channel that I mentioned and set them out, and have, supposing then that there would be a number of provisions that could be common for a number of procedures, maybe with some exceptions and amendments. And the other option would be a so-called omnibus instrument, where we would put together a number of typical amendments to the different legal acts and procedures, so that the instrument would amend existing legal acts. So these are sort of from a point of view of legal form.
Mr. Petri, I'm sorry to interrupt you, but we have our schedule.
I'm finished, actually. So
okay,
what I want to say is that our public consultation on this initiative is open until 11th of May 2021, and I encourage everyone to take part in this and present their responses. And with that, I'm finished. Thank you very much.
Thank you very much. The public participation, the public debate is always a very important tool for democracy to take place. And in this particular kind of issues, that is really, really important.